Yes, my lord, were heard by your lordship that CBI matter that Mr. Tanvir had come only for one document that has been kept pending. Can it be taken up by your lordship anything? Yes.
Maybe pardon to mention, my lord.
You inform the other side also.
Maybe pardon to mention, my lord. My lord said Bharatpur police station case. My lordship had told me to mention after the vacation.
What is happening in that matter?
They have issued the summons to the parties, and this army person's progress in the career has been stalled. My lords. He's not getting promotions and all, so he's not getting posted to. He's only headquartered.
First week of August. If
Your lordship, pardon to mention, your lordship,
Much obliged.
yes,
item number 31.
yes.
On last occasion, I have collected the copy, LCR copy I have received, and I have forwarded to the department. And further, I'll be collecting the read copy, and at 2 weeks time may be allowed so that I get the details from
Okay,
the
next
department.
next Thursday. Okay, next
Hello.
Thursday.
Okay, lordship. Thank you, lordship.
Yes.
I want to mention, my lord, one CRLMC of 2024, my lord. No interim available to the petitioner, my lord. Trial could already proceed with the subject.
CRLMC of this court.
Yes, my lord. 2024, my lord.
No, but it's not marked to this court. Unless it is specially marked to this court, I can't hear it. It has to be mentioned somewhere else.
2020.
Yes. Yes, Mr. Panigre, any development?
Only for this is first I have collected the documents are issuing.
No, what is the problem you are facing? We will find out. Correct it. Okay. Anybody has died in the out of?
Six.
Huh?
6 number 5 is dead. Item 6.
Okay, we will pass the number item number. Please. The item number. We'll pass this. And rest of the matters Thursday, next Thursday.
21st.
Obviously, thereafter only. 23rd.
Yes.
23rd, huh? 23rd. 2 weeks you got. But then next Thursday is holiday. So, yes. Okay. By that time, I think some development takes most of it. Yes.
Up to 81.
Up to 81, huh? Okay. Up to 88.
47.
Yes, ma'am.
Municipal corporation. These cases are no cause of action survives. 47.
47. You are for
For appellant.
appellant. Let us also for the appellant. Then simply against conviction.
No, against acquittal.
Acquittal. Okay. Why it is not surviving according to you?
Well, the municipality and the competent municipal corporation.
Counsel for the appellant submits that no cause of action subsists in this matter. And she doesn't want to close the appeal. According to the appeal is disposed of. Yes. 47. Okay. Disposed of. 47 you, Mr. Panigre. 47 you just strike it out. Yes.
Up to 81 report.
Yes. Yes, Mr. Nayak.
85, my lord, it's a modification of order.
82 confirmation.
I'll just call 8 from 82. Yes.
Supplementary list. Item 82. Modification.
What modification is asking for? 82 modification. Mr. Panigrahi,
Fine.
what had happened in this matter is, the story goes like this. Two boys or three boys went to a massage parlor and raid taken place, and they were apprehended, and a charge sheet was FIR was lodged under section 370 capital A, Immoral Trafficking Act, blah, blah. And they challenged in the first round, challenge. And I passed a judgment saying that, see, they are the customer, they don't have no idea whether human trafficking has taken place or not. They went as a customer, they paid, and they were there. At that time, raid has taken place. So, therefore, human trafficking, you can't prosecute them. I quashed that judgment, saying that human trafficking is, but immoral trafficking act will go on. To that extent, I quashed it, and it was a reported judgment. You can see it. Subsequently, the similarly placed another person came, and the state council, the kind of assistance I get, I quashed the entire thing in subsequent case. Now, a petition has been filed in that reported judgment, say that since in the subsequent case you have quashed the entire thing, why immoral trafficking did you quash that also? Modification is filed. I have adjourned it. It is the duty of the prosecution to ask for modification in the second order. Second order, you move an application. That's the reason I kept on adjourning. Just see it. So that actually the second order is wrong.
Yes.
It could not have been quashed completely. And the petitioner might have said it is covered by the judgment out of, the entire thing is quashed. Should have pointed out that time. So this is the whatever. This is what I'm just simply adjourning,
Fine.
adjourning to next Tuesday. Just see. Look into it. Yes, next Tuesday. Yes, next Tuesday. Tuesday. Yes, 14th. Yes.
Item 83.
What is he asking? Modification.
Madam.
Hmm? What modification?
Recalling the order. IAT 30/24.
Order number 3 dated 13/3/2025. We are supposed to file an additional affidavit.
No, he's asking for what?
Yes.
No, what had happened is, see, in this case, it was quashed on the basis of the affidavit filed by the opposite party, 376 or something. And now the boy seems to be wriggling out of the promise. So therefore, application is moved. I'll issue notice in the application. Let us. Notice has not been issued. Counsel for the petitioners seeks an adjournment to additional affidavit has not been filed. No? Additional affidavit has not been filed. Pursuant to the order dated 13/3/2025, no additional affidavit has been filed by the petitioner. Hence, in the interest of justice, one more will be granted. Please matter on 23rd, 20. Okay. Yes. Mr. Bose, item 82 for Tuesday, next Tuesday. Next Tuesday. Okay.
But coming Tuesday.
Coming Tuesday, 14th. Okay. Yes.
Item 84 at the 11, before 11, my lords, it is in 82.
No, the first till 81, the reports were supposed to come. There is a report. Yes.
I was under impression my lord will be reaching around 12. 80.
This is 80, yeah?
80.
80.
There.
Right. 80. Appellant in some. 80.
Yes, beautiful.
The appellant, Mani Raut, expired of structure, report has come, abated, is
80 is more time to
81. That all this I have given. I have put it on 22nd. I said 23rd. 23rd of this month, so that just see 82 is just now think over. Now think over. Yes. Think over. Okay, I can't say anything. Yes. Now simply urgent to Tuesday. Yes.
84. 84 item. One has been passed, uploaded, and then wrongly entered. I upload it.
He also already.
Download question. Wrongly issued to file the manuals.
Already done. Wrong is. Upload करेंगे
Upload age.
wrong English.
85.
Yes.
I have filed an application for modification. While on 15/5, my lordship, your lordship has granted bail to this petitioner. It's a case under section 307 and other only allied offences. The injuries are simple. 1 year in custody. So while hearing of the bail application, the police has sent 7 number of criminal antecedents, which, my lord, I have complied as per your lordship's direction, filed an affidavit. And while passing the order, my lord, can you see paragraph 8,
Which condition?
my lord, 6. Paragraph 8, condition
He
number
shall be
6,
released on bail.
subject to further verification of similar type of antecedents.
Further verification means
Yes.
whichever has already been disclosed beyond that.
Yeah, beyond that. So I have asked his family members, he has another 3 antecedents.
Then what can be done?
That was not disclosed by the
Then
landed court.
he is not entitled. Not entitled.
Because of that, my lord, he was unable to.
Oh, good. Let him be there for some time. What to do? That's the whole difficulty. They have verified. Have you filed now the details of the other three?
In all cases, he was unpaid.
No, other three.
Lord, he do not remember even those cases are pending. His
Where have you disclosed, sir, that another three cases are there?
my lord,
Which are those three cases?
my lord, paragraph 3
Paragraph 3 in the application.
of the IA.
IA.
It came to like that the petitioner is having all total 10 number of criminal antecedents.
See, particulars are also not there.
Particular also, he also do not know, my lord, the case number and the bail.
I'll issue notice on this application. Verify.
My lord.
See, what had happened is he disclosed 7 number of cases. Okay, filed comprehensive affidavit.
Yes.
Taking note of that, I've granted bail, saying that you further verify whether any more cases is there or not. Subsequently, it is discovered that another 3 cases is there. He has not disclosed that. And now he is seeking modification of that condition. I know, I understand. Difficulty is
That was a year-old case, 2009, 8 or something.
I am issuing notice, let them verify.
My lord.
Subsequently, we will discover
My
that
lord.
15 cases.
My lord.
Who knows?
My lord.
So let him verify. I just issue notice. Okay, issue notice on the application. Huh? Okay, for more days. Okay.
My learned friend may take instruction regarding
Yes.
that.
So particulars of those cases are also
Yes.
not known. Give a
Let
copy.
him I have already supplied the IA. Let him produce the cases. I will file affidavit.
Yes. Okay. I'll put it in the on by 11th August. 11th August. 11th August. By that time. Yes. Let him verify. Tuesday I put it. Okay, 21st. Okay, 21st. Okay. 21st for them.
Item 86.
Yes. Extension of time.
Modification.
Modification, extension of time. Two exceptions for the reason stated in the application. Yes. Yes.
87.
And for the opposite party.
What is the case? Let us understand.
Here, the primary ground of challenge is that the trust was not made an accused.
Now you said that you will give some judgment.
Yes, I've given to the petitioner also.
Company and trust are two different things. In
True,
company
that-
cases, Anita Hada says that you have
that is
to.
applicable,
But
but
what is the position here?
here, so far as this case, Lordship may see para 24.
24. Okay.
I'm sorry, 26. That it is clear that though trust may act or even be treated as an entity for certain legal purposes and not all legal purposes, a trust is an obligation imposed on the owner of the property, beneficiary or charity, and it is a trustee who are bound to maintain and defend all suits and to take such other steps with regard to the nature, land, and maybe reasonably required for preservation of the trust property and association of the property subject to provision, instructions of trust to take such other steps. Then subsequently at para 28,
28,
28 and 29,
yes.
then court has held that 28,
Whether
though we
dress
have,
can be shoe or shoe also. I would like to make clear.
we were called upon to consider as to whether without making trust an accused, if you also may see the last 3 lines of para 28, a complaint would be maintainable against a
We
trustee.
were called upon to consider only as to whether without making trust as an accused, a complaint would be maintainable against a trustee in the eyes of law and NIH. Okay.
Then para 29 that has been answered.
Answer.
question
Hence, the
posed-
question posed is answered in affirmative. And when the cause of action arises due to an alleged dishonour of the check and a complaint is initiated under Section NI Act, the same is maintainable against the trustee and who had signed the check without the requirement of the
who
arrangement.
are in the trust was enacted.
Direct judgment.
Yes. And the judgment which was being relied upon of this honorable, that has been overruled also in this judgment only.
This is 2025.
Lordship.
Which judgment is related? Where is that?
That if your lordship may see para 38,
38.
8,
Yes.
the views expressed by the respective high courts in Prana Educational, our high court judgment is Vijay Manjari Sarpati. Run counter what we have held above. Same do not comment themselves to us and overruled in law without their effect in the parties.
Let us see imbue note. He is relying upon this Vijay Manjari.
Vijay Manjari, which was of this honorable court, but that has been overruled. In that judgment, it was of this honorable court, it was held that in case of trust also, since trust is not made a party, proceedings were
Yes.
closed.
Where is he relying? Let us see.
In the petition, he has not mentioned that, but during courts of argument, it was made. But in the petition, if you lordship may see, that is the primary ground of challenge, para 8.
Para 8 of the petition, huh? Yes.
Para 8 and then again para 9 also, same ground. Raised that.
But he is relying upon some Ismaili Shadi Court versus Gujarat 2016 judgment.
Is that was on the principle of that company being made an accused. But the ground also which they have raised here in para 8 is the same, that the Sushti trust is not made an accused, and para 9 also again it has been stated that the petitioner humbly states in view of submission made above, complaint petition has been filed without giving any details for oblique purpose eventually and without adding the trust who has made the alleged transition with the complainant.
That's the prime ground.
Yes.
You had issued notice to the trust? No.
No, the trust was not made an accused.
No, not when accused, but even notice was
No,
not.
because here I have filed the agreement also. The agreement was made in his individual capacity, and he had submitted the checks. The checks which he had submitted, there his signature was also there, but the trust signature was also there. But the agreement.
Let us see the check if you have. The agreement which you filed the reply. The agreement is.
Lordship, the agreement is.
Yes. Bhavani Traders.
The agreement was, if your lordship may see, I am for Bhavani Traders. The agreement was made by Swarnan to Sai Patnaik. He has been made an accused. So he had made an agreement with us and not the trust. And also in that, if you also may see the next page, page 5. Page 5, last 3 lines. First party member have purchased the aforesaid materials from the second party member of rupees 22 lakh only as credit basis. Against that purchase, the first party member has given some post-dated check as security of the aforesaid amount.
There is a personal capacity.
Yes, personal capacity, he had given the checks. That's why we have made him only an accused.
Okay. Go to item number. Okay. Okay. Yes. Yes.
Item 88.
This is those change decision matters. We had given already after hearing us, Lordship had asked us people notes, we had given notes for submission with the judgment. And last occasion, Lordship asked us to see just more.
This is Manmohan's judgment.
I think we saw it as what it. Up to this, I have not said, so I'm not saying that.
That's what I said. It deals with almost all the situations.
And most important, in addition to this one, in addition, it's a paragraph 15, the presumption. So, presumption is okay, but here they are building up a case of a rebuttal. Rebuttal. That's a matter of trial. So, in the judgment I have given, the 5 judgments, including that particular judgment I have given, what is of this one, 452, there is no scope because it's question of rebuttal, matter of evidence.
Those things will be dealt with there only.
That's all. I have nothing.
Yes, madam.
Now, he's with me. She's with me.
Where is Mr. Prana? Wait for a while. Let us see. If it comes and we will conclude it today. And where are the? Have you given those judgments which you rely upon?
One. I'm not have given in that judgment, they have referred to 5 judgments of the Supreme Court, where courts have the view that this is a matter of rebuttal. A 482, there is no scope.
This recent judgment which you are given, Justice Manmohan's judgment, which paragraph favors you?
Paragraph 15, before that, entire scheme of the, in fact, this judgment is a code by itself.
Yes. That's
It's a
fine.
code by itself.
Yes. Let us see paragraph 15. Is there? Yes, in the present case.
Yes, sir. Paragraph 15. Previously, the court started like this way. Once execution of check is admitted, presumptions under sections 130. So, then they have, here they have referred to another judgment of the Supreme Court of 2008. Creating this presumption, the law enforces the reliability of checks as a mode of payment in commercial transactions. Needless to mention that presumption contemplated under one point of that is a rebuttable presumption. However, the initial owners proving that the check is not discharged of the debt or liability, is an accused bearer of the check. The judgment of this court is APX for its services. The Vedapur Mind Council for the Respondent Accused only says that presumption under Section 139 Act is rebuttable, and when the same is rebutted, the owners would sit back to the complainant to prove his financial capacity, more particularly when it is a case of giving loan by cash. This judgment, he had faced this was the cash transaction.
Yes.
Approach of some courts below, then here court says, approach of courts below to not give effect to the presumption under Section 181.
It's contrary to the mandate of the court.
We are not going to that. Then the other lordship rightly asked them, in fact, that has not stopped my mind, that whether you have replied to the notice.
That's very
How
important.
much importance is given in this?
Yes.
That you get a chance to build your.
That's the idea of the act. 138B, idea is that opportunity is given. If you don't discharge that opportunity, avail that opportunity, then 138 presumption start operating against you.
Then they issue directions regarding the tax.
You are hearing?
Mr. Pandit prefer pass over, my lord.
Okay, he will wait. Have you got this judgment? Justice Manmohan's judgment?
Yes, my lord.
Huh?
Copies have been.
You will deal with this.
Sarah judgment का मिला है? मिला है?
Either they Pope judgment. देखिए, just show him. Show him the file. Just see the file. Yes, next. Password.
89.
May I please, your lordships? My lord,
The
I am
there
appearing
are five
virtually, my lords.
implements of three judgments. Which is three judgments of the Supreme Court, where they have referred another five judgments of Supreme Court on this point, that this is a matter of rebuttal evidence which can be dealt with at the trial in 482. Court should not intervene. It's there.
That's there. Which paragraph, just to point out? Yes, 89.
89.
Yes.
May I please, your lordships? My lord, I am appearing virtually, my lords.
Yes.
In this case, my lord, on the last date, your lordship asked me to go through the judgment in Sanjabji Tari versus Kishore S. Borkar, my lords. I have gone through that judgment, my lord. That is against me. That because the point which I have submitted before your lordships, that relates to competency of the learned magistrate to try the case. So, since your lordships was of the view to keep all these issues open so that it can be adjudicated at the time of hearing, so I pray your lordship may dispose of this matter with the said observation, my lord.
Okay. Keeping all the options open, all the points open, modification review. Okay. I'll pass that on. I'll pass that.
Obligement. Obligement.
Indication देगा. Keeping all the points open. लिख दो. Appearance would have लिख दो. Yes. Yes.
Item 90.
That item 90, my lord, person has not come because better than accident, my lord. The person has to come to get with an accident. Item next Tuesday or the Thursday.
Okay, next Tuesday. Next Tuesday. 14, huh?
Correct.
Pardon to me.
Yes.
Pardon to mention, my lord, item 84, lordship. Already disposed of, lordship, matter is, my lord, sir.
80?
84.
Already.
Yeah, wrongly.
Yes.
Supplementary.
My lord, item 35.
Report.
Reproduction, isn't it? Of 57.
Reproduction. 23. 23.
Supplementary over?
Supplementary.
Yes, Mr. Panda, call Mr. Panda so that we can finish it up. 6 matters. You are ready with the weekly release? How many matters you are ready? Yes.
101 is the
101.
101. Yes.
item 70. What's the item?
So let's see, 101, huh?
Item 70.
70.
70.
Supplementary. Yes, what do you want?
Weekly.
Weekly.
Weekly. 70. Last year. 7. 17. Weekly once now. Weekly 177.
Yes, sorry. 101, huh? Yes, sir.
Conviction. Section 325 like this, 1 year and 5,000 fine.
325.
injury, my lord, the left hand, the claiming left hand fracture. On the occasion of Deepavali, while the injured my lord dusting crackers, there was a dispute and the prosecution order PW1 is the injured eyewitness. He says, my lord,
Who is the eyewitness?
PW1.
Injured.
Injured, my lord, PW1.
Just see, injured.
And knew the accused present in the deck. I am Tamala by caste.
Lucky blow on my left hand.
Left hand.
The result
The
of which
key
I
has not been seized and the X-ray plate not produced before the court. Weapon of offense and X-ray plate. The हाथ भांगी जो कुछ X-ray plate टा
Who is the doctor?
PW5.
5.
Bruises of 3 inch and bruises of 2 inch and 3 inch. In cross exam, all the injuries would be possible by fall.
Simple.
Simple and injury number 3. Next para.
No, grievous.
Injury number 3, grievous in nature and might have been caused by hard and blunt object or fall. The hard surface.
Where is injury number 3? In the first paragraph you see there are two. There are 2 injuries.
2 injuries.
Where is third injury?
On X-ray done at District Headquarters Hospital, Sambalpur, as per opinion given by Dr. S.K. Pati, after specialist fracture of left radius was detected.
This is third injury.
This was referring as third.
Palang injury, he says only 2 injury.
2 injury. And X-ray plate not produced before the trial court.
Grievous is there. Are you aiming at an acquittal? Or shall I keep you?
My lord, last occasion your lordship had at length. Why is my lord? Because my lord, he is a contesting my lord Sarpanch election. That is the my lord, not nothing. My lord, your lordship kindly see the my lord the incident.
Section 12 benefit also you get. Section 12. There is no problem in it.
No, lordship.
I'll record that section 12 also. I'll deal with section 12. I'll say that benefit too. Section 12 very clear.
My
lord. I'll record your argument and then I revert to section 12. I say that the benefit will take it. So that any apprehension is that that's taken care of. Take it. What do you call evidence? I'll deal with it.
Item
See,
87.
yes.
Madam,
He got a direct judgment.
Yes, madam. Madam, just bear me for a moment, madam. In the last part of the judgment, it has been specifically like this. The registry may seek suitable orders from the Honorable Chief Justice of India approves constitution of an appropriate bench to decide the pending reference in special leave number such and such 2019. We clarified that the instant appeal is disposed of and not tagged with the reference. So it means that the similar application is pending and the Honorable...
No, it is referred, but this holds the field today.
Madam, the other referral case also deals with this matter. So my humble submission, still it is pending, I would be before the Honorable Court.
No, but
I don't dispute the fact that the Honorable Court has disposed of this case. I have not the
yes.
But in view of this, my lord, and I have also checked up this case is still pending. So maybe I may be giving a week time, more time to
No.
the development if any put on the court. Otherwise, I will concede to that matter. Because I definitely bind with the honorable court's appeals court judgment. But see the last part of the order, matter. And I have also checked out this particular special petition is still pending, matter.
No, this petition may be specially petition may be pending. But what about is this judgment is arising out of this that's SLP?
Similar issue.
The similar issue may
Similar
be.
issue. So the honorable court has left upon the particular case and special held that this particular case is disposed of, or the particular.
Where is the reference?
Last time
No, that's there. But where is the reference? Where is the reference? It is not referred.
Yes, 42.
Page?
Para 42 again.
Para?
Page
42. Let us see. Yes. Pending reference. Read it.
Well, we are conscious that Pratibha Prasad such and such has been doubted and referred to a larger bench by order number such and such 19. In Tarabai Desai Charitable Orthopedic Trust Hospital, Supreme Court such and such, specially petition such and such. In fact, one of us, Justice such and such, was nominated by Honorable the then Chief Justice of India to be part of 3-judge bench constituted to hear the aforementioned reference. As the learned judge presiding over that 3-judge bench has since demitted office, it would entail nomination of a new quorum. However, till the reference is decided only one way or the other, the law is declared as Pratibha such and such to continue to hold the field as no order has been passed in specially petition such and such. Requesting other benches to await the outcome thereof, there is no doubt on this given the clear dicta in union such and such, which is about such and such.
Read it.
Madam, we are seeing before us judgment and orders by High Court, not deciding cases on the ground that the leading judgment of the court on this subject is either referred to a larger bench or a review petition relating therein in pending. We have also come across examples of High Court refusing deference to judgments of this court on the score that a latter coordinate bench has doubted its correctness. In this record, we lay down the position law. We make it absolutely clear that the High Court will proceed to decide matters on the basis of the law as it stands. It is not once unless specifically directed by this court to await an outcome of the
referential review. That's what I'm saying.
So my humble
It holds the feet.
Why this has come
to decide it.
With all respect, why this has come? Because the fact that during pendency of that particular referral,
No, that is what
this honorable court in a particular judgment has hold that trust will never be a party. Trust is a mandatory party of this honorable court. This honorable court has also taken note of that aspect and said, and this is the final order.
But at the same time, the court says that whatever the agreement is there, you decide the issue. You file written note of submission.
Also, one aspect, this Pratibha judgment is not in respect of possible.
I understand.
Para 21, that is in respect of whether trust is a consumer or not.
Consumer. I know.
This judgment.
I understand.
That issue only.
You file a written note of submission if you want. Huh?
That is one different issue.
Yes.
The Pratibha judgment.
And Supreme Court judgment is also, I will also file also.
That judgment has been overruled.
Yes, that is there.
That is overruled.
I have said so before.
Basically over. Weekly. Yes. Any matter in the weekly you have. Okay. Then let them come. 40. 40. So 40. Yes.
Offense section 325 for bite.
Sorry?
325 for bites.
325. Yes. Yes. What's the sentence? Sentence how much?
Sentence 3 years and 1,000 fine.
Hmm?
Arrived for 3 years and 1,000 fine.
Yes. Period undergone?
That's the trial.
Have you calculated
Yes,
period
sir.
undergone? How much?
5 months, 18 days total.
5 months?
18 days.
5 months, 18 days
Yes, sir.
undergone.
So after judgment, 18 days.
Okay.
Trial.
Total is 5
Total
months?
5 months, 18 days.
18 months undergone. Yes.
Lordship, in the case is that one Barun Bag is missing in the day of the occurrence in the morning.
Evidence good.
From the morning.
Just verify, Mr. Panigri, the period undergone. Incident of which year?
1999.
Hmm?
1999.
Sounds about 1999? 99. What was the age for the accused?
Lordship, now the age is 78.
He's 78.
Yes, sir.
Who is the injured? Injured?
He's died. Also.
Okay. The death case. Okay. Eyewitness, anybody?
That's why eyewitness is PW 2 and 3.
Okay.
But your PW 2, the younger brother, he is missing from the morning and he returned to the house in 5 o'clock. 5 p.m. But he can't be the eyewitness. So he is the post occurrence. PW 3 is the witness, eyewitness, the mother of the.
PW 2, na? We're talking about PW 2 is the eyewitness.
2 and 3 also.
PW 2 relevant party.
Well, let's say PW.
Who is one? One is informant.
Informant also.
Informant, okay. Yes. He's not eyewitness, huh?
No.
Yes. Good.
Let's say PW 2 also can be the eyewitness because he's missing from the morning and he returned to the house in the 5 p.m. also.
PW 2 is not the eyewitness.
No.
He's not the eyewitness.
PW 2.
Hmm.
No, it's in the judgment. In
Which part is?
So I arrived in the house of my grandfather.
Para 2, you are reading?
Yes.
Yes.
My grandfather told each of the accused basically as a picture of one African child age and we most number Mucha Procher Nare Baruch. Thereafter, my grandfather also told that for his false aspersion against him that he had assaulted
Me.
and revoked from which I left the place. Police would have known such allegations.
But he heard it from his grandfather. Brought a lathi and dealt the blow. And with left side of collarbone was of my grandfather. Thereafter, he dealt a blow in the left and wrist. And PW3, what PW3 says? What is your case?
The Lordship, the allegation is that accused blow a lathi blow to the deceased, and he got fracture in the left hand neck and wrist. But Lordship, when the lathi was seized, not in the possession of the accused, and in the judgment at the page 10 of para 8, there is written, he it was pointed out the lathi was seized. Sonjo was not seized from the possession of the accused and cannot be used against him in this case. It is not the evidence of fire and also the evidence of the seized witness that the lathi was seized in the absence of the accused. And it did not.
If eyewitnesses account is there, whether lathi seized or not, that may not be so relevant. How will you get over the eyewitness account and the doctor's evidence?
No, Lordship, all the PW, but all the examined, there are 5 official witnesses and unofficial witnesses. But Lordship, none of the witnesses were examined from the society, Lordship. In neighbor, all the witnesses are the PW and the relatives of the deceased.
And the relative doesn't mean that their evidences will be not relied upon. They are the natural witnesses present in the spot.
Well, the relatives were not present in the spot while the occurrence is.
Are you suggesting that the eyewitnesses, both the eyewitnesses are not present at all there?
So PW2, who is called eyewitness, he is not present in there. And PW3, who is the mother of the informant.
Then because mother, so therefore we will not believe. Why?
That's it.
Unless you create doubt in the cross-examination or something, that statements are be.
Actually, the PW7 is the doctor, and he also stated that on sudden fall on the hard or rough object, there can be a rupture.
Who is doctor?
PW7, 7, 6, and 7.
Six and 7. I don't think there is anything. Yes, Mr. Panigre? Yes. But 3 is very clear. Yes, he saw that telling that the Sondri Gali Devchi brought a lathi and dealt a blow on the left side shoulder of the deceased. Then I offered water to my father-in-law. In the night, Bhuvan and Pandu returned to my house. Then my father-in-law narrated the incident to them. In the night, villagers were called and told about the incident. A village pancho was held. In the morning, due to severe pain, so took the deceased to PS, then the hospital. Then my father died on Friday morning. I think it's a 325 it's made of. Yes, what do you say, Mr. Collins? I think um, I'll grant PO. Not PO. It's not a case of equitable. Yes. Then once they come, you call me. Yeah? Okay. They come. Okay. Do appeal one. Huh? And see, two appeal over now. Just see any appeal is there. And we will do better. Supplementary 88. Supplementary 88.
Supplementary just pass over at the
Fine. Yes.
Kindly look at Annexure 1.
Annexure 1. Yes.
All those questions which your lordship put to me on the last occasion, they fail into insignificance in view of the order at hand.
Annexure 1.
Yes, page 11.
Page
11.
11. Yes. Yes.
Lord may see the accused and their addresses.
Yes.
The court is of the JMFC Bhubaneswar.
Yes.
And the address of the accused is at Raghubir Puri, Aligarh, Uttar Pradesh.
Yes.
Now, my lords may look at the order, latter order. This order arises out of a complaint under 200 CRPC filed by complainant for taking cognizance of alleged offences and to proceed against the accused person.
Yes.
The next page, my lords, listen. Peruse the complaint, initial statement of the complainant on affidavit, original check, intimation slip, postal receipt, postal AD, and the pleader's notice. There is no inquiry made under section 202 PCI, which is mandatory. Mandatory cases where accused resides beyond the territorial jurisdiction of the magistrate.
That is 200 requirement.
Miles.
Yes.
In the Constitution Bench, my lords, in 2021-16 SCC 116.
Can you give that judgment if you
That is expeditious trial of cases under section 138 NI Act.
Yes.
Your lordship may just see paragraph number.
Yes.
Paragraph 24, your lordship.
Paragraph 24, yes.
It says, the upshot of the above discussion leads us to the following conclusions. 24.1 we are not concerned. 24.2 we are not concerned. 24.3 my lords missing. For the conduct of inquiry under section 202 of the code, evidence of witnesses on behalf of complainant shall be permitted to be taken on affidavit. In suitable cases, the magistrate can restrict the inquiry to examination of documents without insisting for examination of witnesses.
Yes.
So 202 has been held to be mandatory, my lords, and it is to be
This is a,
complied with.
we recommend the suitable amendment to be made in the proposals for which is the person of multiple record
At that paragraph 12, their lordships have discussed that.
Yes.
Paragraph 12 is at page 125 of the judgment. My lords will carry this. Para 11 and I'll place one para 10. That is headed inquiry under section 202 of the code. Listen to section 145 of
Para 12 of this judgment?
or para 10. I am placing from para 10.
Yes.
Para 10 says section 202 of the code confers jurisdiction on the magistrate to conduct an inquiry for the purpose of deciding whether sufficient grounds justifying the issue of process are made up. Amendment to section 202 of the code with effect from 23/6/2006 made it mandatory for the magistrate to conduct an inquiry before issue of process in a case where accused resides beyond the area of jurisdiction of the court. There has been a divergence of opinion among the high courts relating to applicability of section 202 in respect of complaints filed under 138 of the Act. Certain cases under 138 have been decided by high courts, upholding the view that it is mandatory for the magistrate to conduct an inquiry as provided in 202 of the code before issuance of process in complaints filed under 138. Contrary views have been expressed in some other cases. It has been held that merely because accused is residing outside jurisdiction of the court, it is not necessary for the magistrate to postpone issuance of process in each and every case. Further, it has also been held that not conducting inquiry under 202 of the code would not vitiate issuance of process if requisite satisfaction can be obtained from materials available on record. Learned amicus curiae referred to a judgment of this court in case Joseph, where there was a discussion about requirement of inquiry under 202 of the code in relation to complaints filed under 138, but question of law was left open. In view of the judgments of this court in Vijay Dhanuka, Abhijit Pawar and Birla Corporation, the inquiry to be held by the magistrate before issuance of summons to the accused residing outside the jurisdiction of the court
Cannot be dispensed with.
with.
Yes.
The learned amici curiae recommended that the magistrate should come to a conclusion after holding an inquiry that there are sufficient grounds to proceed against the accused. We are in agreement with learned amici. Then at para 12, their lordships say, another point that has been brought to our notice relates to interpretation of section 2022, which stipulates that the magistrate shall take for the purpose of issuance of process. 145 of the Act provides that evidence of complainant may be given by him on affidavit, which shall be read in evidence in any inquiry, trial, or other proceeding, notwithstanding anything contained in the code. 145(2) of the Act enables courts to summon and examine any person giving evidence on affidavit as to facts contained therein on application of prosecution or the accused. It is contended by learned amici that though there is no specific provision permitting the examination of witnesses on affidavit, 145 permits complainant to be examined by way of an inquiry, by way of an affidavit for the purpose of inquiry under 202. He suggested that 2022 should be read along with 145, and in respect of complaints under 138, examination of witnesses also should be permitted on affidavit. Only in exceptional cases, magistrate may examine witnesses personally. 145 of the Act is an exception to 202 in respect of examination of complainant by way of an affidavit. There is no specific provision in relation to examination of witnesses also on affidavit in 145. It becomes clear that 145 has been inserted in the Act with effect from the year 2003, with the laudable object of speeding up trials in complaints filed under 138. If the evidence of complainant may be given by him on affidavit, there is no reason for insisting on evidence of witnesses to be taken on oath. On a holistic reading of 145, along with 202, we hold that 2022 of the code is inapplicable to complaints under 138 in respect of examination of witnesses on oath. Evidence of witnesses on behalf of complainant shall be permitted on affidavit. If he holds an inquiry himself, it is not compulsory that he should examine witnesses. In suitable cases, the magistrate can examine documents for satisfaction as to sufficiency of grounds for proceeding under 202. Now, on the basis of this observation, I will ask my lord to kindly look at Annexure 2, that is the complaint.
Yes.
In the complaint, I will ask your lordships to look at page number 15 of the brief. Paragraph 7, subclause 5,
So,
italics 5.
5,
It
huh?
begins that a memorandum of understanding
Yes.
was executed between complainant company and the accused company on 10th June 2021. And according to clause number 2.5 of the said memorandum of understanding, complainant company had to receive stage payments from the accused company. A copy of the memorandum of undertaking dated 10/6/2021 is annexed hereto and marked as Annexure 2. Then what he writes, my lords, learned counsel who has scribed the complaint and which is affirmed by the complaint. At 6, he says, after the accused company received the LOA on 3/9/2020. Your lords, you may just mark this. Complainant company requested it to pay the first installment of 29,54,700 towards its debt and liabilities of technical service fees. However, accused 2 informed complainant company that the land is not still allotted to them. Then they say, even though payment of the first installment was not dependent upon allotment of land to accused company, as per the MOU dated 10/6/2021, and the company was liable to make the payment after issuance of LOA. Again, your lordship may note this. The complainant company, in interest of its professional relationship with accused company.
It is clear that LOA and LOI, after LOI they have done it. LOA should have been done.
Yes.
That you have pointed out.
Decided to wait for payment.
Yes.
Then what he says, your lordship may see. Subsequently, complainant company on verification found the land for the proposed substation had already been allotted to the accused company. Construction works were in progress as per the approved drawings. LOA दिया है, construction किसी है. Complainant company telephonically informed accused 2 that they had verified and found that the land has been allotted and therefore due payment should be made immediately. Accused 2 on behalf of the accused company gave 4 numbers of check towards their liability and debt in favor of the complainant company. I will ask your lordship to note this sentence. And after, my lords, a telephone is made by the complainant that we have verified, found that you have been allotted land. They say that I have issued these 4 checks. So these 4 checks obviously will never be shown in the MOU, which has been signed much before.
Right.
And ask the complainant company to deposit their yes bank check for rupees such and such for clearance. The check is marked as Annexure 3.
Yes.
Unfortunately, I don't have a copy of the check. So I have also not enclosed it, but my learned friend must be having a copy.
That is the reason that column is filled up with handwriting.
ନାଇଁ ସେଇଟାକୁ ଯିବା ତାପରେ ଆଜ୍ଞା ଦେଖନ୍ତୁ ପାରା 10 ରେ କହିଲେ କଣ ଦେଖନ୍ତୁ ପାରା 10 ରେ କହିଲେ to the para 10 ରେ 4th line of ଦେଖନ୍ତୁ but to the utter shock of complainant company check was dishonored for reasons funds insufficient as per the returnment. they did not file a complaint on this dishonor. Then what they say is, para 11, that immediately complainant company informed the accused too about the development wherein accused requested for some more time to arrange funds. Subsequently, finally getting assurance from the accused, complainant deposited the check again on 23 December 21. But the same was again dishonored with remarks 55 account blocked, situation covered in 2125. Now,
But what is this?
whether this is either funds insufficient amounts, whether this reason either amounts to funds insufficient or exceeds arrangement, that is to be determined now. Because a dishonor of check only for these two reasons alone can give rise.
What is the meaning of the account blocked, situation covered?
That, my lords, because I saw it.
2125.
I have also not had the scope to inquire into it.
What is the meaning of it?
So this is the reason for which the check has been said that if the account is blocked, situation covered in 2125. Now, if, my lords, I have handed over this check only after they have intimated me of the request to pay the money after 3/9/2021. Now, my lords, may look at the MOU. The MOU is there at Annexure 2.
Yes.
The MOU is dated 10th of June 2021.
Yes.
That is at page number 26.
Yes.
But at page 31, my lords,
31.
the
Yes. That is handwritten thing.
numbers of the check are given. The dates of the checks are also.
And signature is one signature is
Yes.
there.
Lords, if the checks were handed over much later as per what the complainant is saying, my lords, how can these numbers come in the annexure? And if, my lords, the magistrate is restricted merely because there is a check before him, not to look into any other things, then what happens to Pepsi Food? What happens to this Constitution Bench judgment? What happens to all other judgments of the apex court which say that the magistrate is not to act as a post office?
Yes.
The lawyer will write anything and everything that comes to his mind. And the magistrate, because he sees a check that is attached to it, he is going to take cognizance. This is a very strange proposition of law.
Annexure 3, if you see the
Yes.
check copy of a check
Yes,
is there.
Minas.
One of the checks is there.
This is dated 30/10/2021, they say me.
Yes.
If the check is dated 30/10/2021, how does its number be reflected
In the MOU.
on 10th of June
10th June.
2021 in the MOU?
Yes.
When it has been given much later.
Yes.
So these are the things, my lords, which create a genuine doubt as to how the order of cognizance was.
Have you replied to the notice under 130?
Not at all, my lords. I have not received anything.
What is the averment to that effect in the complaint?
Averment in the complaint is this, yes. Page 18, my lords.
18 para 13. A statutory legal notice dated
Was sent to the registered address of the accused company. Copy of the notice sent through courier delivered on 8/1/2020.
Notice sent through
Our
registered
notice
post.
sent through registered post returned
Not
with a remark not claimed by the postal department.
Yes.
In such circumstances, my lords, my respectful submission is that it cannot be said. I accept, my lords, that a security check does not absolve a drawer from its responsibility. But when does the security check become enforceable? When the contingency arises for the security check to be used. Here the contingency has not arisen because LOA
was not
used. And coupled with that, my lords, the fact that people of Aligarh in the state of Uttar Pradesh cognizance has been taken without resorting to 200. As per the constitution bench, he could have asked for affidavits. Even that was not done. The order sheet only shows affidavit of the informant, complainant is there. Now, if some time would have been granted, I would have obtained copies. But I don't think there is any affidavit to that effect. And even in the affidavit which has been filed, my lords, the very same things which have been stated in the
The complaint is repeated always. Always. In the affidavit form, it is always given. Affidavit. Yes.
So since this is the first case, check has been done without following without the contingency having arisen, the other three checks automatically blurs.
But if 202 procedure is not followed, is it a curable one or
No, it is not. This court has held that it is mandatory. Parsotam Lal Vadhera, my lords.
can't opportunity can't be given?
No, it can be remanded back.
That's what I'm saying.
It can be.
That's what I'm
In
just wondering.
Parsotam Lal Vadhera also it was remanded.
Remanded back. Can I? Right. Yes. What about the inquiry? 202 inquiry. His first point is, apart from merits of the case, he says LOA was not issued because if it is a security check, it is contingent upon when it arises. And the contingent is LOA. LOA was not issued, and therefore security check legal liability is not arisen at that time.
I've got a judgment of the Supreme Court on LOA. What's an LOA? What's an LOI?
Why need not go into this? This is one argument. Second is 202 argument.
In all our cases, in check examiner cases, detailed examination under 202 courts are not going. That's why this affidavit, only this affidavit along with other documents, court can take cognizance on that basis. So materials, and we don't have all those materials, whatever materials, the checks, and court have not mentioned the affidavit specifically. But there is affidavit. That is affidavit.
Initial affidavit, initial statement.
Yes.
Pre-summoning evidence, that
Affidavit.
we can see that.
Along with the other documents. And kindly see there, the grounds taken in the ground. Only this MOU, LOI, LOA confusion, and all other their defense that this check was a security check. Does you know legally dischargeable debt. That's the only ground in their petition. Can you see all the 3-4 grounds only? Paragraph A, B, C, D, E, F. Only. Even this ground has not been mentioned before. It has been developed now.
Most
And court.
Most unfortunate part is, my lords, this is a criminal case.
No,
I am not limited to my ground.
No, that's okay.
I am not limited on
We have
questions of law, my lords. I can raise anything.
Court will go as per records, we go as per records.
Yes.
You know, my respectful submission is this. Justice Judge Monmouth's judgment last week I have read it twice because I knew my friend is genius.
Yes.
So this kind of grounds will come. This was not there before. So the more we deal with this matter, more and more grounds will
Now it is Justice Manmohan's judgment. He has given a format also.
format and
Cuts out the timing.
it's a substitution code. With that, the other 4 or 5 judgments I have referred in Omsel's case in my note minute.
Yes.
That is my argument. That's my argument. All these are possible defenses or rebuttal evidence. They may create any time. It's free. They're free for that. And not on that ground in 432 proceeding cannot be. That's my submission. The proceeding has been stayed from 2002 minutes. 2022.
Regarding inquiry, this cognizance taken as per the provisions of section 138 of the Act is very specific. Under which circumstances, which evidence it will be taken to cognizance. That affidavit evidence court has not examined.
Then even the constitutional bench judgment is also to some extent says that.
Because 202, normally no courts are applying for taking cognizance in the check bounce case.
Yes.
So whatever the concern, the ingredients of 138, accordingly, the cognizance has been taken. And the rest part of what my learned friend submits, whether this is the check is the post-dated check or pre-dated check, or as per the debating the contract of the MOU, that will be all decided in the trial.
No.
So cognizance is rightfully taken without any error and illegal.
Okay. You give it.
I have only one line to reply to what my learned friend is submitting. That all courts take cognizance in 138 cases without complying in section 202. Can such a statement be recorded in the Honorable High Court? No, Mr. Kara is saying so. Can such a statement be recorded and taken into consideration? If the Constitution bench says that it is to be done, Mr. Kara's statement.
The Constitutional bench judgment, if you read,
Doesn't say.
No, sir, it does say so. Please read it.
The Constitutional bench judgment, the para 12, the last it says in suitable cases, magistrate can examine the documents
on
for satisfaction.
Exactly.
There is sufficient ground for proceeding under one.
Exactly. And is to insist and can take state 202 inquiry on affidavits has to be done. That is what it says.
That affidavit is taken.
No, sir.
Witness 202 inquiry kind.
Only complainant evidence.
I am only making a small submission. Normally, your lordship should have called for the records. Your lordship may call for the Xerox copy of the record being transmitted. Your lordship may
that is
reserve
there
it.
apparent on record. Therefore, only complainant affidavit was filed.
Exactly.
It is apparent.
202 code.
And the other documents were examined. That's all.
Documents were not examined. He in
the impugn order it writes, I have perused this
peruse କରିଥାନ୍ତେ ତାହେଲେ ତ ଆଜ୍ଞା ଦେଖା ହେଇଥାନ୍ତା ନା କମ୍ପ୍ଲେଣ୍ଟ ରେ ଲେଖା ହେଇଛି LOA ଇସ୍ୟୁ ହେଇଛି ସେଟା ନାହିଁ exactly so I vote off. I will only request your lordship may call for the records in the Xerox format.
Yes.
If no 200.
I will kindly speaking, but there is the impugn order which they have been
I'll-
that everything has been declared.
Definitely. Thank you. Thank you. Thank you. Yes. Weekly.
Weekly item 73.
The conviction was under 333 for 1 year. Initially, they were charged with 332, 333, 379, and 307 along with 34. But the learned trial court has already dismissed all of the other charges and only convicted for 323. Basing on the
Yes.
basing on the statements, they have consistent statements regarding the accused person's assault on PW3 only, which was stated that he along with the tippy of a cardboard card hit PW3 and PW3 sustained injuries on his chest.
Yes.
PW5 is the doctor, your lordship. The doctor has stated clearly. I'll read that statement. Paragraph 5, your lordship. PW5, paragraph
5, huh? BL5, para 5. Okay.
On 21/12/2003, I gave treatment to the patient Ranjan Behra of village Chanagar, PO Kusumati, district Khurda. At the time of treatment, he was serving as a postcard under Ranpur Reach. As the patient was complaining of his chest, complaining of pain in his chest, I referred him to Capital Hospital, Buddheshwar for further investigation and treatment. After the return of the patient from the Capital Hospital, Bhubaneswar, it is found from his discharge certificate that there was no fracture and surgical emphysema on the chest of the patient. In the cross-examination of Your Lordship, he has also stated that there was no visible injury. Had he been struck with the tippet of a car, there had to be some visible injury, Your Lordship. Plus, there was no exhibit of the Capital Hospital Bhubaneswar reports.
Yes.
Now, coming to PW3 statement, the injured person, Your Lordship. Page 5, paragraph 30. He clearly says that I was examined by the police at Ranpur. It is not a fact that
Let us see what are the allegations. Para 2. Read Para 2, PW3.
The occurrence took place on 21/12/2003 at 7 p.m. at Jasodapur Chowk. By then, I was the forest guard at
So beat. Yes. On that day.
Also beat on that day. On the verbal direction of the range officer Ranpur Range, I accompanied the foresters Pramod Kumar Kanungo, Karada Station, and Dr. Chandan, Ranpur Sadar section, forest guards PW1, PW2, and PW8
Yes.
to Mala Forest on patrol duty. After performing the patrol duty, while we were returning towards Jasodapur at Jasodapur Chowk, we found the aforesaid 6 persons bringing sal and teak balas in 6 numbers of buffalo carts. The forester Pramod Kumar Kanungo demanded permit or any other authority from the accused persons in support of the said forest product, but they failed to produce any permit or any other authority. The accused persons were bringing the said balas from Mala Forest Reserve Forest. The forest guard Charan Jena seized the 6 numbers of cart with balas on the spot and prepared the seizure list. No seizure list has been executed. After the seizure, forest guard Charan Jena directed the accused persons to drive their carts with balas to Karadapala Beat House, but the accused persons forcibly drove their carts towards the village. So and so. Myself and forest guard Charan Jena were in front of the first cart. The first cart belonged to accused Ghansham Swai. Accused Ghansham Swai dealt a blow by means of a tippet to my left side chest, causing pain. The said accused Ghansham Swai also dealt a blow to the waist of forest guard Charan Jena PW2 by means of the said tippet. The other forest staff removed myself and PW2 to Government Hospital Ranpur. Thereafter, we were referred to Kalinga Hospital Bhubaneswar for better treatment by MO Government Hospital Ranpur. The accused persons forcibly removed the carts with the logs to their village.
Let us see PW2. Relevant part.
The relevant part is paragraph 4, Your Lordship. The other all paragraphs are the same. The narration is slow. How they went up. Myself and Ranjan Behra were in front of the carts. Accused Ghansham Swai dealt a push to the belly of Ranjan Behra by means of tippet. When I protested the accused Ghansham Swai as to why he assaulted the forester Ranjan Behra, he moved his cart easily. As a result, the front portion of the cart dashed against my chest. I fell down into a ditch. By that time, the cart of the accused Ghansham Swai fell towards the left side. As a result, the ballas under the cart dashed against me. Due to such dashing, I sustained severe pain on the middle of my waist. I lost my consciousness there. On the next day at Kalinga Hospital, Bhubaneswar, I regained my consciousness. For about 7 to 8 days, I remained in the hospital as an endo patient. I sustained fracture on my waist.
Yes.
PW5 has clearly mentioned that PW2 was not referred to Kalinga Hospital. And then in the judgment, page 18, Your Lordship.
Page 18, huh? Yes. Yes.
PW, fifth line, Your Lordship, it is written PW5.
1 minute, para.
Paragraph 15 on page 16.
1 minute, paragraph 15, huh? Yes. Yes.
Line. PW5 revealed that on 21/12/2000,
Where are you reading?
page 18, Your Lordship, fifth line.
Fourth line. Fifth line.
Okay. PW file revealed. Similarly,
Similarly, PW5 revealed that on 21/12/2003, he has examined PW3 and found patient was complaining pain in his chest, for which he was referred to Capital Hospital for further investigation. And after return from the Capital Hospital, he found no fracture and no surgical assistance. PW5 has not proved any report of Capital Hospital, for which it cannot be said that he has gone through the report of the Capital Hospital. He has not mentioned any OPD number or any referral number in the Exhibit 2 as to prove that he has examined PW3 on 21/12/2003, although the requisition was made on 25/12/2003. Thus, evidence of PW5 is also not above the reproach to be relied on to prove his opinion with regard to the injury sustained by PW3. The lower court has very seemingly dismissed the PW5 statement production. And further, on page 21, Your Lordship, last 5 lines,
PW5 is not believed.
not believed.
Yes.
On page 21, last 5 lines, Your Lordship.
Yes.
I find in the instant case the evidence of PW 1, 2, 3, 4, 8, and 9.
Well, 21 which per? Yes, I find the instant case. Yes.
Are not acceptable to prove discharging duty as public servant, seizure of property, and removal of property. I'll stop here, Your Lordship. If there was no seizure of property or removal of property, or they were not serving as public servant when they were discharging discharging the duty, the whole mention of PW3 being hit by the accused person goes away, Your Lordship. Because no cards were seized, no ballas were seized.
But it says, but their evidence is credible to prove the assault by Ghansam to PW2 and 3.
Again, the court has dismissed PW2 being injured by the accused person, Your Lordship. So they have the lower court has very selectively relied upon one part of everybody's statement because it is consistent. Lordship, it is not proved beyond reasonable doubt.
But 2, even if you remove 2, insofar as the 3 is concerned, he is sustained injury.
He has sustained no
And that corroborates with the PW5.
But only chest pain, Your Lordship. No other injuries were corroborated. There was no visible injury. Had he been hit by a tippy or any other physical object, as mentioned, blunt weapons, Lordship, there had to be some form of visible injury outside.
For 323, visible injury is required.
But Your Lordship, chest pain will be caused for a number of...
You can't presume, but whether for 323, any kind of injury, is it necessary that it should be visible? If the even chest pain is caused because of the injury, 323 is satisfied. Internal injury may also cause pain. Let's see PW5 what it says. Yes, Mr. Panigra, yes, see PW5 is not believed by the PW5 is not believed, PW2 is not believed, only PW3. Where from you draw corroboration? Conviction is 323.
Yeah.
Ranjan Vera is PW3. Are you PW? Paratri, yeah? Yes. What is that?
I'll read the full paragraph.
I have not examined any doctor in the capital hospital. PW2 has not stated before me that the assault by the accused Gansam and he received blow on his chest, but he has stated that he has not. Similarly, he has not stated before me that. Yes. Gancha.
Yes. Not stated in the ancestral statement and the contradiction.
There is a clear contradiction. 5 is not believed.
Yes.
Then evidence they come.
PW8 is also there.
Eight.
Should be cross-examination.
8 PW 8, huh?
Yes.
So let's see.
The aspirant fact is concerned.
No.
Para four.
Come on. Let's see. Are you witness?
Yes,
He-
please go there.
He was a first guard what?
Yes. Yes.
Yes, para 4, huh?
Yes.
Yes.
Forest guards, Hon'Ble and Charan Jana differently cards are moving towards village delivery and sleeper for acting. Unless my dead blow by means of typing to the chest of the forest guard Hon'Ble acting. Ghanshyam Swami also dealt the blow by means of the typing to the right chest of Charan Jana, receiving the blow on the chest. Charan Jana fell down. In the cart of active Ghanshyam, he capsized the Balna in the cart that's against the request of Charan Jana and the fracture. Yes, the IO. So this part is confronted to the IO.
Let's see. Where is that?
Last 6 lines, PW8.
PW 8, last 6 line. Yes.
Not stated.
Para 9.
It does not stated.
Para 9.
Yes. Para
Para
3, IO.
Para 3 IO. Para 3 IO is there. He is also same, like PW3, PW2. It's not stated. The same.
That's the first time.
First time in the court. Para 3 for the IO. Actually, demolish the entire case. Yes. I think yes, something. Will you give in writing? Written notes up. Give. You understood what he said. Have you understood what he argued? Ask him what he argued. Okay? And prepare a note. Let him prepare a note at least. He should. Prepare it. Okay. Thank you. Yes, madam. You have any matter? Which item? 77. Offense? Huh? 363. Ready, ma'am?
4 numbers. 1 year 500. 101 days under 1. 1 year 500 rupees fine. 101 days under 1.
101 days undergone. 1 year and 500 fine.
Pardon.
Yes.
Item 97, my lord. Charge under section 376 and 417, subsequently converted to 417, that is cheating on the promise of marriage and conviction of 1 year. My lordship, there is scope for acquittal. Today morning my printer conked out, so I couldn't get the printout of the
You can take it now.
So can it come next week?
Yes, yes, no problem. Take it. Take the printout.
And I will take the.
Yes, yes, of course.
Then I'll be able to assess
Yes.
my lordship comprehensive.
But now in BNS, there is a specific offense for that.
Yes, my lord. Section 69 is the specific
now.
offense. But because it does not have retrospective effect, my lordship will confine myself to 417 and promise.
Yes.
Next week, let it come, my lord. I will
Definitely, definitely.
Well, my lord, I got 98. After this one, my family called.
98.
Madam. The appeal of 2009.
What was the age? That time 37 years. No, 24 years.
Now,
Hmm?
now 37.
37 years old. See, he was 24 years that time.
So then some.
What are the offenses?
324, 6 months conviction. When I sent the status report call for already very difficult because the engaging counsel is already died in the meantime.
I'll grant PO and finish it up. Why are you worried?
Lordship disputed just now. 3 months, serious 7 FIR registered. 324.
Grant PO.
No purpose will solve because engaging counsel is already expired. I have to contact the client. I am not only as per the constitutional address.
Grant PO and finish it up unnecessary.
Some days is in custody because 307 I initially registered. Thereafter.
Can you just tell me what the period of custody Mr. Panigve can also tell you? A period of custody लिखी PO कर दिया. Period of custody लिखी दिया. And PO. And you get the benefit of section 12 also, no problem. PO कर दिया. Period of custody Mr. Panigve. Just check it up, please. You can. PO. Thank you.
Weekly item 28. I need Paranman. Item 27 or 500.
7.
27. Weekly 500.
Weekly.
What time matter? I mean, pension matter, retirement.
We'll see on Tuesday.
Pardon to make a mention.
Next Tuesday. 14.
What's the item?
Yes.
What's the item 65 not press loads? 65 not press.
Supplementary list.
No,
Weekly.
list.
65.
Not press.
What's the भैया item? 60?
65.
65.
You are for appellant? Hari Behra?
Lord, sir.
Hari Behra matter?
Yes, Lord, sir.
Give him.
Lord, sir.
Opinion, dispose of. Yes. Item number 28. 28. 28. Yes.
Lordship.
Mr. Naik is there? Sarthak Naik. Yes, Mr. Naik, you are there. Okay. Yes.
Lordship, challenge is made to the
You,
movement and order
Mr.
of
Hall,
government.
you are in which matter, sir?
Number 46, 48, 56, 48.
It may take little time.
Let me run it here.
So therefore. Then let it be next Tuesday.
Yes, sir. 46, 48, 50.
Next Tuesday we'll do it.
CBI, your lordships.
Yes,
CBI matter, your lordships. This coming Tuesday, I have some difficulty. Let it be on Thursday.
No, I will hear it insofar as Jiva matter is concerned. I'll hear it. I'm talking about Mr. Dhal's matter.
In one of the matters, he's also your lordships for CBI is a party, Parsuram or something.
No.
That is item number 34. And then it's
34. 34. No. 34 I'll accommodate in the Tuesday because he has two more matter argue. The CBI matter will be argued later on. You are ready with this Vasudev Purohit matter, na?
Yes, Your Lordships.
Yes. Okay.
I've also filed a written note. Your Lordships have directed me to file a note.
Your junior is there. We can give it. Ask your junior to be here. Huh? Okay. Yes.
That's it. Conviction for the offense under section 5 railway.
Oh, sorry. Yes, Mr. Naik, I got it. It is there. Written note is there. Okay. Thank you. Oh, yes.
That's it. Conviction for the offense under section 5 railway 51D of the Prevention of Corruption Act 1947 and
Please use the mic so that you can hear it. Yes.
sections 420, 120B of the Indian Penal Code.
Yes.
And the sentence is RI for 1 year and to pay a fine of rupees 10,000 in deferred RI for 2 months.
Yes.
The allegation leading to this case is that, Lordship, the appellant was working as the field officer of SBI ADB branch Balangir, Agricultural Development Bank branch Balangir.
Yes.
And the co-accused applied for a loan of 60,000 for purchasing of a boring machine.
Yes.
And the allegation is that while applying for such loan, he filed false advance cash memos issued by the Messrs Sujata Supplying Agency and Engineering Works Raipur. It is alleged that no such firm was in existence and the co-accused obtained a false quotation memo on the basis of which
you have sanctioned the loan.
Lordship,
you have sanctioned the loan.
No, my stand is that I am not concerned with that. The veracity of the quotation is not put to scrutiny by the bank. That is why the guarantee is being put on, and that is why the criminal case is being instituted. If somebody makes a false declaration, so the bank is to believe the quotation. And the allegation against the co-accused is that then secondly it is stated that signature of the guarantor in the loan application was forged. Then the third allegation is that forged clearance certificate was obtained from SBI Tarawa. No dues certificate, the present appellant as the field officer issued a form for no dues certificate obtaining no dues from the bank where he had taken the loan earlier.
Yes.
And it is the allegation is that forged clearance certificate was obtained by the co-accused from the bank in question. Then the loan was sanctioned on the basis of the appraisal report of the appellant. That is another circumstance allegation against me. And lastly, then it is alleged that the co-accused went to Raipur, opened an account in the name of Messrs Sujata, deposited the draft and withdrew the amount. The co-accused did that. Then the last circumstance against me alleged is that the appellant went to Raipur to verify the factum of purchase of the boring machine on 23/2/1981 and returned on 1/3/1981, did not submit any report. So from these circumstances, the prosecution has alleged that the appellant entered into a criminal conspiracy with the co-accused as the firm was non-existent and accordingly facilitated in getting of the amount by the co-accused, and thereby the bank was cheated. It is the allegation. So Now I will take your honor to the charges framed against me, which is at page number 73 of the paper book.
Paper
Lordship
book,
may kindly,
where is the paper
on
book?
the computer itself, Lordship may kindly come.
Paper book is there? They give the paper book. Yes. 70?
73. Charge
Yes.
with 3 heads. The first charge, your Lordship may kindly see. Firstly, that I am reading, Lordship.
Yes.
That you on or about during the period 1981 and 1982 at Balangir agreed to do or caused to be done an illegal act, namely commission of offense of cheating, forgery, and forgery for the purpose of cheating, entered into criminal conspiracy, and that you thereby committed an offense under section 120B IPC, read with section 420, 467, and 468 IPC, and within my cognizance.
Yes.
Lordship. Now, Lordship will see that conspiracy is not done by a single person. Conspiracy must be with another person.
Yes.
For the offense to be complete. The charge does not mention as to with whom I entered into the conspiracy.
Yes.
So the charge is absolutely wrong.
Yes.
And on the basis of this charge, I cannot be convicted of the offense under section 120B of the Penal Code. I rely on 2 decisions on this count, Lordship.
Yes.
The first one is the case of Jagannath Mishra and others versus State of Orissa, para 5. Lordship may kindly see para 5.
Yes.
What is the citation, CLT or OCR or what is it?
Lordship, it is reported in 19. What is that?
40 within brackets 1974 CLT 1253.
1253.
Eight. Para 5, Lordship, page number 2 at the bottom. The learned
Para 5?
Para 5. Lordship, may kindly.
Yes.
The learned assistant session judge dealt with the case of the prosecution in general and thereafter referred to the evidence against each of the 18th paragraph, so also not required. Then come to next para 6. Though 2 separate appeals have been filed, one set of argument.
Sorry, 1 minute. I'm not getting.
Para 6.
Para 5 is there.
Para 5, 6. No, that's in my comment.
6 yes. No, two separate.
So 2 separate appeals have been filed. One set of argument was actually advanced at the time of hearing. Counsel for the appellant contended that the prosecution has failed to establish any criminal conspiracy as provided in section 120A of the Indian Penal Code. That section provides when 2 or more persons agree to do or cause to be done an illegal act or to an act which is not illegal by illegal means, such an agreement is designated as criminal conspiracy, provided that no agreement except an agreement to.
But where does it say that in charge it is necessary to be mentioned?
Charge is necessary because, Lordship, the basic thing. The criminal trial begins with the charge.
No, that's right. But charge it is necessary to mention that with whom you have conspired.
Yes, Lordship. For example, Lordship, let me say, Lordship, we cannot charge a person that you committed murder. To whom he killed, who was the person killed, the name must be mentioned.
Yes.
Otherwise, the charge will be deficient. and it will be thoroughly illegal because the person will not be.
What is your answer to 464 CRPC?
464 will not. This is not an.
It may be an error.
It cannot be corrected.
Error, but that will not vitiate the entire.
It will vitiate the trial.
Show me any judgment to that effect.
Yes. My humble submission is that non-mention of the person with whom I supposedly entered into a criminal conspiracy is a defect which cannot be remedied, and that renders the whole trial illegal.
Show me the judgment.
As regards, I will.
One small interjection, Your Lordships. Your Lordships, for a moment accepting without admitting for the sake of argument that sir is correct, then they could have challenged it at that point of time instead of facing the trial and getting conviction. If the
That's right. Therefore, 464.
Yes, 464.
Therefore, 464.
Trial errors or omission regarding formal charges.
Therefore, I'm saying 464. Yes, that's what I'm saying. Unless you overcome 464.
Answering the argument advanced by my learned counsel.
Yes.
That I did not challenge the charge after it was framed does not debar me from challenging it in the appeal.
No, you can do it unless you show.
But this is not a curable illegality. This is not curable. This
even in the face of 464.
Your Lordship, we should read 464.
464 will not remedy it. My humble submission. I will find some citation.
You get some judgment.
Yes.
So we can read.
Then
we can read 464, Your Lordships. For your Lordship's convenience, sir can read 464.
Yes, I read it. Therefore, I pointed out.
Yes,
to get over that. Yes, you are right.
Not argue in piecemeal manner.
Yes. Let him conclude. Mr. Naik, let him conclude.
We will not. On each of the points, I will be telling.
No, I will not do that.
Yes.
No, not like that.
Yes. This is the first time.
Then Lordship may kindly come to the second charge.
Yes.
Secondly, that you being a public servant employed as field officer, Agricultural Development Bank, State Bank of India, Balangir, during 1981 and 1982 by corrupt and illegal means and or by otherwise abusing your position as such public servant obtained for Sahadev Sahu, the co-accused, pecuniary advantage to the extent of rupees 60,000 from ADB SBI Balangir and thereby committed an offence specified in section 51D of PC Act 1947, read with section 52 of the said act and within my cognizance.
Yes.
Lordship, the basic ingredients are that the person either takes the pecuniary advantage himself or permits somebody to take the pecuniary advantage.
Yes.
Being the public servant. So the necessary ingredient is that the person must be the disbursing authority and control over the money which is being disbursed. If it is money,
yes.
If the pecuniary advantage is money, then the person must be the authority. Now here the evidence on the record is conclusively clear that the sanctioning authority of the loan is the branch manager and not the field officer.
Yes.
The branch manager was made as an accused initially. The transaction, the occurrence is of the year 1981. The FIR was registered in 1985. At that time, the branch manager and the person, the concerned accountant cum cashier, was also made as an accused. But later on, the CBI did not charge sheet them. Now, I will take your honor to the relevant evidence, just one line each on the evidence. Lordship may kindly come to page 117 of the paper book, the evidence of PW5 in para 4. Page 117, 117.
Yes. Para 4.
Para 4.
Yes. The branch manager shall be at liberty.
Right.
Yes.
The branch manager, relevant SBI filed a suit against the guarantor realization of the loan. The document is total pecuniary advantage, the genuineness, and the person 67 pecuniary. The background to the amount certificate was within the branch manager shall be at liberty to refuse sanction of a loan even if the same is recommended by the concerned field officer. So how can I may be liable for the offense under 5(1)(d)? The ingredients are not met out. Then I will take your lordship to the deposition of PW3 in para 5 at page 107 of the paper book. PW3 in para 5. 107. 107 page. PW3.
PW3
para 5.
page?
Page 107. Hmm? 104. Sorry, Lordship. 104 page. 104, Lordship. Sorry, Lordship. It is PW5. 104 page, Lordship. Mechanism. Para 5. I cannot say when Mr. Goidar joined in his interview. I was in that today for the first time I am deposing. I never deposed before. The branch manager is the sanctioning authority of loan. Unless he is satisfied, no loan can be advanced from the bank. This is also an official of the bank, senior official of the bank. So this being the evidence.
Which part? You said branch manager?
Lordship, page 104, Lordship, last line. Para 5.
Sanctioning authority of the
Lordship. Lordship.
I never deposed before the court.
Lordship.
In any manner or some way. The branch manager is the sanctioning authority of loan. Unless he is satisfied, no loan can be advanced
from the
bank.
So this being the evidence of the prosecution, the charge under section 5(1)(d) fails. Then we come to the last charge. Page 73. Page 73.
Yes.
Hardly, Lordship. That I am reading, Lordship. That you during the years 1981 and 1982 at Balangir cheated the authorities, State Bank of India, dishonestly inducing to accept, inducing, Lordship, that is, inducing to accept false appraisal report. This is very important, Lordship, may kindly mark. False appraisal report, number 1. Clearance certificate, false clearance certificate, and false guarantee bond against loan account number ATL 7/31, and an amount of Rs 60,000 was sanctioned and disbursed to the co-accused without purchasing the assets on your recommendation, and you thereby committed an offence punishable under section 420 IPC and within my cognizance. So the basis of the cheating are 3 things as mentioned in the charge. First one is false appraisal report. Second one is false clearance certificate. And the third one is false guarantee bond. So far as the clearance certificate and the false guarantee bond are concerned, I am not convicted of the offence under section 467 and 468 of the Penal Code. I am acquitted. I have got no connection with forgery. The learned trial court has accepted it. Now the question is whether the appraisal report submitted by me, along with on the basis of which the loan was supposed to have been sanctioned, is there anything false in the appraisal report? Not a single word has been brought out in the prosecution evidence that anything is false in the appraisal report. So the charge, as mentioned, for the offence under section 420 of the Indian Penal Code fails, Lordship.
You are not doubting the charge, but you are saying that this charge could not be proved.
Charge cannot be
Could
proved.
not be proved. Yes.
Lordship.
Because of
Then we
the reason it refers to 3 documents.
Lordship.
Out of which 2 documents.
2 documents I have already been acquitted.
Acquitted. So only 1 document
Only
is there.
1 document
And there is no evidence to the effect that there is a false appraisal.
Yes, there is anything false in the appraisal report.
Yes.
So the charge under section 420 fails.
Fails.
And accordingly, my humble submission is that all the charges fails. As mentioned, the first one, as I submitted, the person with whom I conspired, committed the conspiracy, the name has not been mentioned. This is a serious illegality, as there can never be a conspiracy with a single man. For the conspiracy, for the offense of conspiracy to happen, there must be a second person.
Yes.
And if the second person is not mentioned, then with whom I entered into conspiracy is not there, the ingredients are lacking. And as the ingredients of the offense are lacking, this is a serious irregularity and this cannot be remedied. And accordingly, the charge fails. The second charge I pointed out that I have no authority to sanction the loan, and accordingly, the ingredients of section 51D are not made out. And so far as the third charge is concerned, I pointed out that 3 documents are being referred. 2 of the documents I have already been acquitted, and prosecution has not led any evidence, a single word of evidence to show that the appraisal report is false. Now coming to the evidence on the record and the impugned judgment on the basis of which I have been found guilty. So far as the offense under section 120B of the penal code is concerned, so far as the charge under section 120B is concerned, Lordship may kindly find that the learned trial court has listed the circumstances in the impugned judgment I am showing, Lordship. Lordship, para 6 of the impugned no, little letters. Little letter also. Lordship, it is there, Lordship, I am pointing out. The first circumstance which has been relied on by the learned trial court, there are 5 circumstances. On the basis of which
trial court has called out all the.
Yes, Lordship, I will point out the page also. For the charge under section 120B IPC, there is no direct evidence that there was any criminal conspiracy with the co-accused. However, the circumstances which are pointed out by the learned trial court are 5 in number. Number 1 is that the appellant was with the co-accused on 11/2/1981 when the latter gave proposal to the branch manager. That is the first circumstance, Lordship.
Yes.
Then the second circumstance is the letter by Exhibit 2 appears to have been false. This is the clearance certificate, as I pointed out.
Yes.
No dues clearance certificate. Then the third circumstance, the appellant had identified the co-accused to the branch manager for the purpose of loan. Then, the fourth circumstance, PW4, who is the branch manager, sanctioned the loan on the basis of the recommendation of the appellant. This is the fourth circumstance. And the fifth circumstance is that the appellant failed to ensure purchase of boring machine even though he went to Raipur. These are the five circumstances from which the learned trial court has found. It is there in my note of submissions. But may kindly get my note of submissions.
Your note of submission is not.
My note of submissions is there. But may kindly come to page number 5 of my note of submission. Charge under section 120B IPC. ये देख लिया है note of submission. I have filed lots there. પછી મેં તે court seal is also there.
The note of submission is not here.
It's not there. Then I will file another copy.
Please keep
it. It is not there.
Okay. Yes.
Then I will file another copy. So these are the five circumstances. Now let us come to the first circumstance. The first circumstance is that PW4, Lordship may kindly see the evidence of PW4 speaks in para 3 of his deposition at page 106 of the paper book. Page 106 of the paper book. What are you looking? Para 2.
Yes.
On, Lordship got it? On 11/2/81, the borrower proposed Sahadev Sahu, Sukadev Sahu, accompanied by the field officer Sri Purohit, led a proposal before me for advancing a loan in favor of Sri Sahu. This is the first circumstance utilized by the prosecution and the learned trial court.
Yes.
Lordship. Now, my humble submission is that this evidence of PW4 is absolutely false and proved to be false on the evidence on record. Now, in order to disprove it, I urge my Lord to kindly peruse the deposition of this witness at para 11 at page 110, 111. Para 11 at page 110, 111.
Yes.
The quotation, Lordship got it?
110, na?
The para 11, Lordship.
Yes.
The quotation in respect of the boring machine was produced before me on 11/2/81. Except making an
endorsement
regarding the margin money to be deposited by, then the some lines, Lordship may kindly omit, then come to the concluding 4 lines of this para on the page 111. The deposit of Rs 21,000 by the borrower with the supplier is dated 25/12/1980. So the deposit of 21,000 by the borrower with the supplier is dated 25/11/1980. Admittedly, the quotation has been produced before me after 20/12/1980 and before 25/12/1980. Lordship got it. So 11/2/1981. The branch manager says that I took the borrower to him and led the proposal for advancing the loan. That is the date when the loan application was made as per the evidence of PW4.
Yes.
In chief. But in cross-examination, he admits that the loan application was filed by the co-accused in between in the month of prior to the month of December 1980, at least in between 2012-1980 and 25-12-1980, the borrower had met the branch manager and had submitted the quotation to him of the farm, which was non-existent. And moreover, I will take your lordship now to the deposition of the IO PW 17 in para 17 at page 169. PW 17 is the IO who speaks in para 17 at page 169.
Yes. 169. Is PW?
17. Lordship got it?
Yes.
Accused B. Purohit joined as field officer in SBI ADB Bolangir in the year 1981 during the month of January, and prior to that he was an officer of that bank. Prior to January 1981 he has not worked as field officer. So there is no question of my laying any proposal before the branch manager, and that circumstance should not have been utilized as an incriminating circumstance against me.
Because you didn't work prior to?
Prior to, because I joined as field officer in January 81, and in February and in December 81 there was the loan proposal, and the person borrower had produced the quotation as per the evidence of the branch manager in between 2012-1980 and 25-12-1980. And there is a very important factor in this. My lord may kindly appreciate. The allegation of the prosecution is that, lordship, the allegation of the prosecution is that the borrower had put a false quotation memo in the name of Messrs. Sujata Supplying Agency, which was a non-existent firm, in order to avail the loan. So, the mens rea on the part of the borrower is filing prior to the filing of that quotation.
Yes.
Because the firm was non-existent. I was nowhere in picture by then.
You came in January.
I came into picture in January 1981.
Yes.
So the question of entering into a criminal conspiracy
Doesn't arise.
with the borrower does not arise at all.
Yes.
Then,
by that time he has already done whatever.
yes, lordship. Then I take lordship to the second circumstance. The second circumstance relied on by the learned trial court is that the appellant was with the letter by exhibit 2 appears to have been false. Now, I will take your honor to
second circumstance.
the second circumstance. For this, I will take your honor to the deposition of the manager of SBI Tarova, who had issued the no dues certificate by exhibit 2. He has been examined as PW2 and he speaks in paras 2 and 3
At page?
at page 96 and 97 of the paper book. Lordship, I am reading.
196. Yes.
While working as Lordship, I will
96 which paragraph was it?
2.
Paragraph 2. Yes. while working?
While working as branch manager Tarawa, I received a letter from accused Sukadeva Sahu sent to me through accused Vasudev Purohit requesting me to issue a no due certificate. This is the said letter marked Exhibit 2. I am acquainted with the signature of accused Vasudev Purohit. Exhibit 2/1 is his signature on Exhibit 2. On receiving the Exhibit 2, I verified the accounts of Sukadev Sahu to ascertain whether he had any outstanding dues. On verification of the accounts, I found that there were outstanding dues against Sri Sukadev Sahu, and I mentioned the particulars of the dues in my hand on the certificate portion of the letter Exhibit 2. The particulars which I mentioned on the certificate portion of that letter are not there and have been erased. Exhibit 2/2 is my signature on Exhibit 2. A portion of that signature has also been erased. The particulars of dues which I now find on the certificates are not in my hand. Accused Sukadev Sahu had 5 accounts in Tarawa branch. On verification of those accounts, I found that he had a total dues of 34,343.5 outstanding against him on 17/2/81 in account number so and so. I mentioned the account number like this. So, the evidence of PW2 is that the no dues certificate was issued by me. So with that, the proposer of the loan is to go to the bank where he had the account and to bring the details from the bank. He bought that. And what he did, he erased it. The writings he erased. And accordingly, he wrote something else, stating that there are no dues appearing. And in the handwriting in which he has written, the PW2 says that I have not written
Let
that.
us see that exhibit.
Handwriting.
Let us see that exhibit.
Exhibit 2. Exhibit 2 tadi.
Exhibit 2.
Let's see, computer.
Yes.
Let's see, can. If you file that.
With party is erased. Nothing is erased.
Current account. This is the Exhibit 2 statement of the loan application. Note of Chief General Manager. Beginning account.
In the exhibit 2, nothing is erased.
So I had also not verified, but it must be. It will exhibit 2 quota. Exhibit 2.
Agriculture finance.
No, Lordship, what has happened? The erasing is not visible to the naked eye.
Which part then?
He stated that he had mentioned it on the body of Exhibit 2, but that has been erased. That is his evidence. Lordship got my point. And accordingly, the document, the certificate portion, Lordship, may kindly see. Tarabha. Certified that certificate portion जोटा अच्छी Lordship देखिले तो तार तले जोटा अच्छी agricultural finance रो तले certified that Sukadev Sahu, son of so and so, Tarava has been granted by us an advance of etki, has not been granted any advance etki. SBI.
I think the scratching here has not been granted any advance. Just see the document. This has been done by him.
Yeah.
Has not been granted.
No, not been. He says that I had written something else. And my writing has been erased. And something else has been written, which is not in my handwriting. Now, what has happened, Lordship? This was not visible to the naked eye. And for that, the document in question was sent to the handwriting expert. And the opinion of the handwriting expert was obtained by the CBI. But neither the handwriting expert has been examined, nor the report has been marked as an exhibit in the case, proved in the case. And from that, an adverse inference is available to be drawn against the prosecution under section 114G of the Evidence Act.
Yes.
That had the evidence been produced, it would have gone against the prosecution. And that is why it is not produced. So my submission is that, Lordship, there is absolutely no evidence by the prosecution to show that after I issued the no dues certificate, this document was received back by me.
Yes.
This is the linking evidence, and there is absolutely no evidence on that score. The applicant could have produced this directly before the branch manager and not before me. We do not know.
Yes.
And moreover, the lack of evidence by PW4, who is the branch manager, on this score is telltale. And it proves that the branch manager, as I pointed out to the evidence, the branch manager is the authority to sanction the loan. And the evidence is that he can refuse the loan even if recommended by the field officer.
Yes, that's it.
So, if that is so, then the branch manager also would have produced this document.
Yes.
And this forgery was not detectable to the naked eye. So, how can I detect it?
But
And
in
how
any
can
case,
this be utilized as circumstance against me?
but trial court did not believe it and acquitted you.
Yes. Yes.
Yes.
So, for this cannot be once, my humble submission is that once I am out of the charges of forgery, utilizing these as a circumstance against me is wholly unwarranted.
For the purpose of
For the
420.
purpose of 120B, for the offense under section 120B.
For 120B, read with 420.
420. Then, Lordship, I come to the third circumstance. The third circumstance is that, Lordship, I had identified the co-accused before the branch manager. It is part of my duty to identify
That's not.
as the field officer, the loanee, and it is not the case of the prosecution that the identification was wrong in any way. The identification was correct. He is the person. It is a different matter that he devised dubious means to get.
It says that you know
the identification.
You know the criminal, therefore you are a criminal.
Yes. So the question
That's
of
neither here.
identification cannot be utilized as a circumstance against me.
That can't be. That can't.
Then coming to the fourth circumstance, Lordship, that the appraisal report, the loan was granted on the basis of the appraisal report. As I pointed out to your Lordship at the beginning, there is nothing in the evidence of the prosecution to prove that the appraisal report was wrong in any manner. Anything mentioned in the appraisal report is wrong. So, that the loan was advanced on the basis of the appraisal report cannot be utilized also as a circumstance against me. The loanee was granted a loan for the purchase of boring machine at Balangir. Balangir is a drought-prone district, your Lordship knows. And there, I had mentioned that there is high potential for irrigation, both for cultivable land and for domestic purpose. So boring machine is a profitable business. That is, I'm not wrong with that. Then the second thing that is mentioned in the loan application is that the loanee was a ex-Air Force personnel and he had experience in the matter. He had worked in the technical capacity in the Air Force. And so the loan was within a scheme which was approved by the DIC, District Industries Center. And that is also mentioned in the loan application.
Yes.
So these are the circumstances which show that why I advanced the loan, and nothing mentioned in the appraisal report can be said to be false.
Yes.
And moreover, as I pointed out to your lordship at the beginning, the appraisal report can be rejected by the DM.
Yes.
It is open to him to reject the appraisal report. And there is no evidence by PW4 that he granted the loan as because
You are neither the sanctioning
I misled him.
You are neither the sanctioning authority nor the disbursing authority.
Not the disbursing
Only your field
authority.
officer. Some documents were given to you. You have forwarded it to
Lordship.
the branch manager.
Lordship. My humble submission is that, Lordship, in order to
And all these things happen in December 1980, and you join in January
81.
This is what is the story.
Lordship.
Yes.
Then I come to my one sentence regarding this particular aspect, Lordship, this allegation. The branch manager has not pointed out in his evidence that as because of the appraisal report I had granted loan, and had the appraisal report been not such, then I would not have granted loan. So that proves that the loan was simply not advanced on the basis of appraisal report, and nothing in the appraisal report is wrong. We come to the last circumstance. The last circumstance is that, Lordship, it is stated that on 23/2/1981, the branch manager instructed me to go to Raipur for ensuring purchase of boring machine by the co-accused. This is the last circumstance. And the evidence of the branch manager, PW4 in para 5 at page 107. Lordship, may kindly see.
Page
107, PW4, para 5. I instructed the field officer, Sri Purohit, to accompany the borrower to Raipur for purchase of boring machine. First sentence.
Yes.
Lordship, got it?
107. Yes. Field officer Purohit. Para 4, huh?
Lordship, para 5.
5, yes.
First sentence.
I instructed you.
The field officer, Sri Purohit, to accompany the borrower to Raipur for purchase of boring machine.
Yes.
Lordship. This statement is completely wrong, Lordship. Evidently, the statement of PW4 is not correct. PW4 admits in para 12, Lordship. Para 12, para 12, correct. Para 12, para 12, page 111 of the paper book.
Usually the field officer of the bank. Fill up.
Last 4-5 lines, Lordship, may kindly say. I have no personal knowledge if the borrower and the field officer proceeded to Raipur together. See.
I have no personal knowledge.
Then I will take then one sentence above that, Lordship, may kindly see. On 23/2/81, accused Purohit was relieved from the office in the afternoon to proceeding to Raipur. Lordship, got it?
Yes.
So,
para 13 also read.
Say para 12.
Oh, para 13 also read. I was examined by the CBI officer.
Then
I do not remember if I had stated before.
This is also a contradiction. I do not remember if I had stated to the IO that I instructed the field officer to accompany him to Raipur. Then I will show the deposition of the IO PW 17, the point your lordship had picked it. PW 17 at para 17 at page 170 of the paper book. So I have to read para 17.
Para 17.
Sorry. Sorry, Lordship. Para 18. Para 18, Lordship, may kindly see. Para 18. I have examined Prahalad Sahu PW4. He has not specifically stated before me that I instructed the field officer to accompany the borrower to Raipur, but he stated that he deputed BD Purohit to Raipur to see the purchase and its smooth delivery. Lordship got it?
Yes.
So this is also a contradiction.
Yes.
The circumstance that has been utilized by the learned trial court is also an important contradiction and should not have been utilized. Moreover, the evidence of the prosecution is that, Lordship, the draft in question was delivered to the co-accused on 22/1981. On the 20th of February. And I have proceeded to Raipur. I was relieved as I showed the deposition to your lordship on 23rd. So the occurrence of cheating was completed on 20th at the time when the draft was received by the co-accused.
Draft received on
20th. This is an admitted case. My learned friend cannot dispute it. On 22/1981, the draft was handed over.
20 February 81.
Yes, Lordship.
81.
Lordship.
Proceeded to
Raipur on 23rd. The offense of cheating was completed by the time he received the draft. That is the valuable security he received, for which he had done the cheating. So anything after the occurrence cannot be utilized as a circumstance to prove that there was a criminal conspiracy.
Post occurrence circumstances.
Lordship. Then the most important thing, Lordship, regarding this fact is that Lordship, I will take my lord to the deposition of PW 17 in para 17. PW 17 in para 17 at page 170 of the paper book.
Yes.
I have the code.
Yes.
To work in branch, last 4 lines, Lordship. There is no document or paper except the oral statement of Prahalad Sahu that accused B. Purohit was deputed to ensure the purchase of boring machine from Messrs. Sujata Supplying Agencies. This is very important because an official act, when somebody is deputed and relieved from a particular office, then a written order needs to be made. It cannot be on an oral direction. And Evidence Act says that when a particular fact is required to be incorporated into a document, then the document is the primary evidence. The oral evidence is secondary evidence.
Yes.
So the primary evidence is lacking. There is no document to prove that I was deputed to Raipur.
But there is contradiction in the sending to
Contradiction is also there, but my submission is that the document also is not there. Then I will take your honor to another important circumstance. So, what has happened? The branch manager has stated that 23 to 81, I was relieved in the afternoon to go to Rai. This is the evidence of the branch manager. Your Lordship has seen it. The evidence, on the other hand, it is the case of the prosecution that on 23 to 81, on the first hour, the co-accused opened an account in the bank at Raipur in the name of Messrs. Sujata Supplying Agency, introducing himself as the proprietor of that firm.
And deposited that.
And deposited the bank draft. So, by the time these things were done, I was nowhere in picture.
Yes.
So, when I went to Raipur and the TA bill, which has been submitted and marked as Exhibit 17, I think, 17, reveals that I was at Raipur from 24th to the 1st of the month.
Yes.
So evidently in the night of 23rd, after I am relieved from the bank, I have gone to Raipur from Balangir.
When the bank,
and it takes the whole night.
When the bank account was opened?
I returned on fast this state.
No, bank account was opened by co-accused.
23rd, first hour.
Okay.
I reached Raipur 24th. And the TA bill mentions that I was at Raipur. Evidently, I went in the night because I was relieved from the bank in the afternoon of 23rd, as per the evidence of the branch manager. So, the thing is that my humble submission herein is that, so what I would have done when I reached Raipur, for the purpose of argument, even though not admitting, let us assume that I was deputed to Raipur to ensure the purchase of the boring machine by the co-accused. So I was required to go to that shop and make an inquiry as to whether the co-accused has purchased the boring machine or not.
Yes.
And it is the evidence of the prosecution that the farm was non-existent. So now in such light, I will take your honor to the evidence of the evidence the admission of the appellant that
In 313.
313 that he had gone to Raipur. Although he has not stated that he had gone to Raipur to ensure the purchase of the boring machine. Now, Lordship,
Let us go to 330.
okay. I reached Raipur on 24th to 1981 and I have it is my stand in the 313 statement that I went to Raipur, went to the address and found that there was a board in the name of Messrs. Sujata Supplying Agency and the shop was closed. I made inquiry from the nearby adjoining shopkeepers and they stated that the proprietor is out and is not there. And thereafter I fell ill at Raipur. That is my stand in the 313 statement. Now, so far as whether there was a board of the Sujata Supplying Agency in the particular address or not, I will take your honor to the evidence of DW1, who was the field officer of SBI ADV Balangir in 1984, and he has submitted his report by the Exhibit C in a departmental inquiry, which is at page 171 of the paper book. The evidence of DW1. Lordship, may I kindly speak? I was working as field officer of State Bank of India ADB branch Balangir Sri D.B. Bohidar was the branch manager of the said branch. He had deputed me to Raipur in August 1984 for conducting an inquiry. Accordingly, I had gone to Raipur in the said month. I conducted an inquiry and submitted a report before the branch manager. Exhibit C is the carbon copy of my report. Exhibit CY1 is the original signature. CY2 is the endorsement with signature of the branch manager. Sri D.R. Bohidar, I am acquainted with his signature. The spot of inquiry was a very big building. No farm in the name and style Sudhar Supplying Engineering Works was located in the said building. I inquired from the nearby shop owners and came to know that such farm was in existence in that building about 3 to 4 years back. One company by name Rajesh Engineering Works for supply of
What this? How it will help you? He said 5-6 years back it was there.
3 to 4 years.
3 to 4 years.
1984. 3 to 4 years back, he went in 1984.
The evidence was.
So, 3 to 4 years back, he speaks about 1984. He went and made the inquiry in 1984, not from the date of his deposition.
Yes.
So, it was in existence in 1980-81. That is his evidence that can be referred. Now, I will take your honor to the evidence of PW6 in para 2 at page 103 of the paper book. PW6 in para 3 at page 103 of the paper book.
Yes. Regarding what?
PW6. Kete page?
103.
In para 3. 119 Lordship page.
119.
Yeah. Language comprehension. When official the Sahu. Lordship, para 3 I am reading out. Accused Sukadev Sahu has practiced fraud as against ADB branch, Bolangir and State Bank of India, Tarwa branch in relation to the purchase of boring machine for which money was advanced by the bank. The findings of my inquiry are based on the documents maintained by the bank in due course of official business. The demand drafts issued in favor of the supplier are ordinarily handed over to the borrower to facilitate purchase. During my inquiry at Raipur, I conducted one Mr. Rajesh Rathore, who is one of the partners of Rajesh Engineering Works. I visited Raipur in 1983 to conduct the inquiry. It was gathered during inquiry that during 1981 first quarter, a board mentioning the name of Sujata Supply Agency and Engineering Works was hung near Rajesh Engineering Works. That was the address given. So it is the deposition of both the bank officials who had conducted the inquiry. Then I will take your honor to the deposition of PW17, the IO, in para 15 at page 168 and 69 of the paper book.
Yes.
After, let's see, I am reading para 15, page 168, last sentence.
Yes.
After examination of witness Narottam Mishra, it came to my notice that a signboard of Sujata Supplying Agencies was displayed in front of Rajesh Engineering Works during the relevant period, but this fact could not be substantiated from any other source. Rajesh Rathore denied this fact. I have not asked Rajesh Rathore about this fact, though I inquired from the locality that nobody came forward to make any statement before me regarding displaying of the signboard in front of Rajesh Engineering Works. It is a fact that there is nothing in the case diary to show that I made investigation in this aspect. Whatever is stated from his own memory. It is not borne out from the case diary, which an investigating officer is not required to do. However, he admits that the board was there. And what investigation he has done? The investigation is not fair. Then the prosecution, Lordship, has relied on this evidence to show that the farm was non-existent. And the prosecution has also relied on the evidence of PW12, who is the guarantor of the loan. Sorry, Lordship, not the guarantor. Who is the introducer of the accused at the time of opening of the account in the name of Sujata Supplying Agency at Raipur. It is PW12. So what he speaks, I will show to Lordship. PW12 speaks. PW12, the deposition I am reading, Lordship. PW12. I have an engineering workshop at Moudapada, KK Road, Raipur. Its name is Rajesh Engineering Workshop. I am selling spare parts, manufacturing boring machine and other job works in that workshop. I know accused Sukadev Sahu since 1978. He was my customer. He had purchased boring machine and other spare parts from my shop in 1979 and 1980. I have account in State Bank of India Raipur branch and it is being operated till today. My account number is 6/683. I had introduced Sukadev Sahu when he opened an account in SBI Raipur branch. I introduced him on 23/2/81. I personally went to the bank and introduced accused Sukadev Sahu, thereby putting my signature. Exhibit 27/2 is my signature. Accused Sukadev Sahu opened the account in the name of Sujata Supplying Agency and Engineering Works, KK Road, Raipur. Sujata Supplying Agency and Engineering Works was not in existence at KK Road, Raipur when I introduced the accused Sukadev Sahu. At the time of introduction, accused Sukadev Sahu told me that he was going to open such an agency and engineering works. Accused Sukadev Sahu had issued exhibits 38, 41 and 42 for payment towards the spare parts taken by him. After 1981, accused Sukadev Sahu had not come to my shop and I had no dealing with him since 1981. The CBI officer during investigation of this case collected my specimen signature as per exhibit 43, 40, so and so. I was examined, cross-examination. I was examined by CBI officer in the year 1985 or 1986. I was examined in my workshop at Raipur. The CBI officer had asked me about the past dealings of Sukadev Sahu with me and I had shown our bills and other papers to him. I had produced bills and vouchers.
I got it. Who all are the initially who were charge sheeted?
Charge sheeted only the co-accused and myself.
Sukadev.
There were two other. This man is an accomplice. That is what I am showing to.
No, Sukadev was.
Sukadev is the co-accused, borrower.
He has been acquitted or what?
No, he has not been acquitted. He was being tried with me. He jumped bail in the midst of the trial.
What happened?
And their case was split. And thereafter, the judgment was delivered against me. I do not know what happened to him thereafter.
Yes, Mr. Nayak, what happened to Sukadev?
The fact which sir is stating is correct, but what happened after that, your lordship, I need to ascertain whether.
That's very important.
Yes.
Whether he has been acquitted. What happened?
I'll find that out, your lordships.
Because if he is acquitted, even otherwise 120p will not stop.
That is very crucial, your lordships, yes.
Very, very crucial to know. Then only we can proceed. Because we need not labor hard if there is an acquittal ultimately. That benefit will flow to him. Because he is the principal accused basically. He has done it. Because he has joined in 1981. By that time, almost all the thing he has done. Almost everything he has managed. and he might have given little money and pushed the papers and got it sanctioned through branch manager, and branch manager has sanctioned and taken. And he may be, Mr. Moon's client may be a small fry in the entire game. Evidentiary value is different. This is the story. He cooked up everything, Sukadev, and gave it to his client. He pushed it to the branch manager. Branch manager sanctioned, taken the money and all. And he is a small fry in the entire game. Branch manager is let off. Sukadev, what happened to Sukadev, we don't know.
Though
This
named in the
a middleman is stuck here.
though named in the affair.
Middleman is stuck. Can you please ascertain?
Yes,
That's
yes,
very
Your Lordship.
crucial, you know.
Very, very
If he is
crucial.
acquitted or something happened, then we can very well. Or his appeal is pending. Maybe appeal, he might have been convicted, appeal is pending, we don't know.
I'll find out, Your Lordship. It's very crucial. Lordship may give me some time. I'll find out.
See, you try, Tuesday will continue.
Tuesday, Your Lordship, was difficult. Thursday, Your Lordships.
Thursday will continue.
But Lordship, my submission, let me conclude. I have not much time.
I got the overall thing. You need not. I understood.
So far as
See the five circumstances.
the position of this witness is concerned, this witness has admitted in cross-examination that he had received money out of the amount which was deposited by Sukadev Sahu, that draft. He had received money. So my submission is
all the
that
arguments will
not
be a
only
futile
he introduced, although he says that the farm was not in existence, but he has also received benefits. And in order to save his skin, he has a deposit like that.
Yes.
So this evidence of the man being an accomplice has not much evidentiary value. And this cannot be
Having said that, I have received it.
Lordship.
Part of the money.
Lordship.
See,
And
the
so far-
circumstances which you are talking about, page 9 of the paperwork, it is there, all the five
Lordship.
circumstances. Five circumstances are there.
And so far as this concludes about the 120B, these are the five circumstances as mentioned.
You please give your written note of submission. You have concluded, I'll hear him. I'll hear him.
Kept it to Thursday, I will give it before that.
Oh, okay, it's all right. Next Thursday, 23rd. 23rd. Part heard, concluded. I have noted down your argument. And you please give a written note of submission.
Today I am giving.
And Mr. Naik will ascertain about Sukadev and then proceed.
Yes,
Okay?
yes,
Okay.
2 p.m. Your Lordship may listed at 2 p.m. Thursday.
Lordship,
23rd, 2 p.m.
23rd, 2 p.m. 23rd.
Lordship, I have highlighted some portion, I will make.
No problem. No problem. It will be helpful to me. It will be stable mark.
Lordship, it is always
Stable mark is correct. Don't miss it. 23rd at 2 p.m.
Sir can give me a copy also, Your Lordship, of the note so that I can go through it. Say note type.
You do one thing. He will collect. His junior is there.